Defamation revolves around the concept of reputation. Freedom of expression may be restricted to protect the rights and reputations of others, and so defamation laws are in principle a legitimate restriction, provided that they also comply with the second and third parts of the three-part test, which requires that restrictions are provided through clearly worded and freely accessible laws, and that they go no further than is truly necessary in a democratic society. In terms of modern human rights law, there is some debate as to whether there's a freestanding right to a reputation. While the International Covenant on Civil and Political Rights provides protection against unlawful attacks on a person's honour and reputation, the drafters of the European Convention on Human Rights did not believe that a right to reputation should be protected as such. However, in recent years, the European Court of Human Rights has understood the right to reputation to be protected as part of Article 8 of the European Convention, which protects the right to private and family life, but only if the attack on reputation attains a sufficient seriousness to qualify as an intrusion into one's private life. So who can sue for defamation? Is this open to all persons? How about groups of people or objects, such as a flag, or institutions, such as the army? A number of European countries still have defamation laws on their books, often dating many years back, that protect the national flag or the army or other institutions. European human rights law has a very simple answer to this. In none of these instances is there an individual human person whose reputation may have been infringed. Many defamation laws, either in intention or in practice, are used to address issues that should properly be the subject of other laws or of no laws at all. In particular, defamation laws are often misused to penalise criticism of government officials or of other public officials. International jurisprudence supports the view that governments and public authorities as such should not be able to bring actions in defamation or insult. The Human Rights Committee has, for example, called for the abolition of the offence of defamation of the state. While the European Court of Human Rights has not entirely ruled out defamation suits by governments, it has limited such suits to situations which threaten public order, implying that governments cannot sue in defamation simply to protect their honour. A number of national courts, for example in India, in South Africa, the United Kingdom, the United States and Zimbabwe, have also refused to allow elected and other public authorities to sue for defamation.